which also exist for this citizen or non-citizens are Article 14, 20, 21, 20, 21A, then 22, 23, 24, 25, 26, 27, 28. So these are all necessary things which are also available for the non-citizens. Now today as we have understood that we are reading about the fundamental rights and fundamental duties. So we have come across what is introduction, then evolution of fundamental rights, then also characteristics of fundamental rights. So in characteristics, it's justiciable in nature. If you have to write a point-wise answer, first understand what are the specific points. First one is justiciable in nature, then second one is citizen and person. Then next concept is not absolute. So what is not absolute? These are not available 24/7. So this could be restricted at any point of time if there exists, example, a national emergency under Article 352, national aggression and war. Then suppose if it's Article 369, 359, President can suspend all the fundamental rights except those mentioned under Article 20 and 21. So this concept, liberty, right to liberty and thought. So this liberty and life. So this you can understand the fundamental rights, as we say, which are specially designed for state to control its power over citizens, could also be suspended at certain point of time. So under conditions like 359 and 352, so I cannot go to even court under such situations saying that this violation or this absoluteness has created or have violated my right to be there as a citizen. So now these are two possibilities of fundamental rights. First is negative and second one is positive. So Article 15 and Article 17 and 18 are negative injunctions. So now what are these negative injunctions is these impose restrictions on the state. So that is why it is negative in nature. Then positive is right to freedom, speech, expression, provides six other freedoms of citizens, and these are positive in nature. So this Article 15 and 60, 17 and 18, they impose restrictions on authority of the state to look into. They are not fully available, like their space is not fully open, but rather the right to freedom of speech, expression as a citizen, I have been pushed to follow or focus so that my rights would not be violated. Then also another important thing is the limitations. We are talking about the limitations. This is restricted to armed forces, the martial courts or anything. If I cannot go to normal court saying that my fundamental rights have been violated. So because in concept of armed forces or paramilitary or any NSA, so this comes as a the very threat to the Indian nation. So if something like it's threat to Indian nation and the armed forces and all these things, all these organizations have authority, they can restrict my fundamental rights. So I cannot simply approach court saying that as it is threat to nation, it is not threat to me. But in spite of that being a concept of threat to nation, you are violating my you are restricting my fundamental rights. So I cannot go to court of law in such situations. Then enforceability. So this they are enforceable except something like bonded labor, where if government or the state thinks that my service could be used for the community betterment, then that cannot be considered as a bonded labor. Then that restriction could be uplifted. Then also I cannot go to court of law saying I have been forced to do this work. So if it's for the betterment, I have to do it. So these are possible restrictions. Of course, everything comes with restrictions. So these possible restrictions are as such. Now next one is classification. Now this is very most important thing. You have to remember the fundamental rights, and the classification is where students usually lack this understanding, and usually this is what that makes the difference from a student who knows the classified fundamental rights and basic fundamental rights, like these are 66 fundamental rights and so on, so and so, but you have to remember the article number and a certain set of provisions they are under. So part 3, article 12 to 35. So then amendment, then repeal 31 right to property, then added as a legal right 300A, etc. That is for other day. Now right to property. Right to equality, freedom, right against exploitation, right to religion, cultural and educational rights, right to constitutional remedies. So you have to remember all these things for you to understand the fundamental right, the six things. So right to equality comes is addressed under Article 14 to 18. Right to freedom is under Article 19 and 20 to 22. Right against exploitation is 23, 25. Right to religion is 25 to 28. Then cultural and educational rights 29 and 30. Then constitutional remedies is under Article 32. Now let us understand what is right to equality. So what are Article 14 to 18? We have to understand uh, or the crux of what does that article bear, what right does it hold. So this is the equality before law and equal protection of law, prohibition of discrimination on grounds of caste, color, creed, sex, religion, and equal opportunity regarding employment, abolition of untouchability, and abolition of titles. Now, equality before law and equal protection of law. So, and also, I shall not be prohibited on the. I have to be. Everybody is equal before the law, and the law shall give this concept of it should protect everybody equally. Yes. Then prohibition of discrimination. I shall not be discriminated that I belong to certain caste or I belong to certain gender or my color is different or my religion is different. Then also I shall be given equal employment, then equal opportunities in employment and abolition of untouchability, yes, Article 17. Then abolition of titles, like I shall not take any or accept any titles from a foreign national unless I've taken permission from the president. Then right to freedom is under Article 19 to 22. Now what does this articles hold? So it's freedom of expression, speech and assembly, then movement and residence and settlement and profession, protection in respect of condition for offences, then protection of life and liberty, then protection against arrest and detention in certain cases. Now, right against exploitation, Article 23 and 24 holds prohibition of traffic in human beings, then prohibition of employment in children in hazardous employment situations, then right to freedom of religion. So I have freedom of conscience and free profession of any religion that I like to. Then freedom to manage my religious affairs, then freedom as to payment of taxes for promotion of any particular religion, freedom to attend religious instructions. So I shall not be restricted from attending any religious institutions unless they are threat to uh, national security. So then under cultural and educational rights, which are Article 29 and 30, we have protection of language, script and culture of minorities, then rights of minorities to establish and administer educational institutions. Now next comes right to constitutional remedies. So this is enforcement. This is very important. Now this is enforcement of fundamental rights, and also writs are also addressed under this Article 32. Now next comes what does this Article 12 defines. So it defines state. Now this is very typical, interesting topic. Whenever there has to be a shift, if you talk about the word state. So, if we are talking about state in Western political perspective, we are talking it as a concept of nation-state system. So, the state as such is a geographical boundary with the certain elements of power, etc. But whereas it comes to state as a concept in or comparative politics, or this has to be termed as an the central, the secondary authority, like the state here we refer in India while talking about Indian political sense. So we consider it as a secondary institutions. The first institution is for the union, the secondary federal institutions which have come together, that we consider as a state. But here in Article 12, it defines state as both central authority, state authority, and the local authority. So, all whatever is under power or whatever is elected to be democratically elected and associations working, those all should be considered as a state. Now, what does Article 13 state? Says no law should be against the fundamental rights, and state also should not make any law against the fundamental rights. So initially there has been a controversy where the I think it was during Indira Gandhi's those 42 and 42nd amendments. So the DPSPs were given upper hand rather than the fundamental rights. So after altering court judgments and etc. and amendments made to Article 13, the fundamental rights, if there's an discrepancy between fundamental rights and DPSPs, the fundamental rights should be addressed. So the DPSPs, Directive Principles of State Policy, should not be given upper hand than the fundamental rights. So if government makes any law thinking that I am following for DPSPs, which are specially meant for the states to address the certain fundamental principles in making a policies. So if they make any laws based on that, but if those policies are said to have violated my fundamental rights, then the state cannot say that we are making policies so that it could be for their betterment. So it cannot simply cut down my fundamental right as a citizen and say that we are addressing that policies for the betterment of you. So the fundamental rights should always be given upper hand. So and also if state should not try to make any laws which are against the fundamental rights, because if they have said to have happened in judicial review, we know that the courts are going to interfere and they're going to declare those acts or policies as void or ultra vires. Then next concept is right to equality. This is very important. Of course, all fundamental rights are important. You should not just get confused. Now, what is right to equality? So, right to equality is addressed under the four: Article 14, Article 15, Article 16, Article 17, and Article 18. So, what does Article 14 says? That everybody is equal before the law, and states should ensure that equal protection of law should be given to all the citizens in all any other conditions. But there are also limitations. So, this limitations is in case of president, governor, ambassadors of foreign nationals, they are given some little immunities in addressing that them and the normal citizens shall not be treated on equal conditions if there's any discrepancies. So this is what Article 14. Every article comes with a limitations that is what very important for you to read as being a undergraduate student in political science. This is how this helps you understand both the positives and the negative sides of fundamental rights. So this is like critical reading. So the critical reading is what makes you a brighter graduate. So the Article 14 also says that equal before law, equal protection of law, but also limitations for the presidents, governor, ambassadors, etc. Now next comes the Article 15. So Article 15 says, I shall not be discriminated on basis of my caste, on basis of in the name of religion, then gender, place of birth, anything. But there are limitations. Uh, it's called a protective discrimination, which says that the state can provide extra benefits to promote the interest and well-being of women and children. So this is the other limitation in Article 15. Now, Article 16 is considered equality of opportunity in matters of public employment. But also state can also provide the opportunities for the backward classes, for the scheduled caste and scheduled tribe to maintain this protective discrimination so that these communities will be pushed further. So this Article 16, although it says equality of opportunity, but this also comes with a limitation that state can also provide reservations. Now Article 17 is it abolishes untouchability. So we know this social untouchability is the social evil. So glad that this has been abolished and anything against if said to have been followed. So the cases have to be booked. So this abolishes untouchability. And Article 18 is citizens should not accept any titles from the foreign states without the consent of Indian president. But the India always gives this Paramvir Chakra, all those awards, Bharat Ratna. So that is those are all citizens of India are entitled to take those, but they should not accept any titles from foreign nations. Okay, so this is Article 18. Now, next one, another, this is the most important article uh, for you to exist as a citizen, and enjoy your rights as being a citizen. So this is right to freedom, which is addressed in Article 19 to Article 22. Now, what is Article 19? So this Article 19 further comes with six other freedoms. So it used to be earlier 17, sorry, 7, then the Article 19F, 1F has been removed. So the Article 19, we have 19(1)(a). Now, what does this 19(1)(a) talks about? To have freedom of speech and expression. Then 19, then B talks about to assemble peacefully. So now this assembling or forming an association or taking a rally is a basic fundamental rights, unless I am provoking anybody or I am carrying any arms, or this movement is a threat to the nation. So these things are all allowed unless you're not doing the above said things. Now, to form associations and unions and cooperative societies, then to move freely throughout the territory of India, then to reside and settle in any part of India, then to practice profession or to carry any occupation, trade, and business. Again, this comes with valid restrictions. So I cannot do any profession in exotic animals or like drugs, narcotics, etc. So the I cannot say that it is my right to practice any profession. So that those are little violations. And to reside and settle or to move through any part of India, see, there are certain restrictions while in moving through certain part of Northeast India. So we have to take permission before the visiting such places. So because I cannot compel go to court and say my right to move freely throughout the territory has been violated. So this everything in fundamental rights comes with little restrictions. You have to. That's why they are called as consigns. They test the human intellectual, human capacity to analyze things. So I cannot blindly say that I have this right to assemble. Then I can assemble with arms. I'll do this violent, aggressive movements. Then the state shall not restrict those things. Any citizen should not say those things. Now to reside and settle in any part of India also, the initially before scrap joining the Jammu and Kashmir, the other citizens were not allowed to buy or purchase or reside in those parts. But once the abrogation of article was done, then any citizen of India, so any resident of all over India can buy a land or reside in such places. So this is also changes were also made to such things. You have to understand the limitations and the possible restrictions to those. Then right to freedom is subject to many reasonable restrictions. Now, under what conditions my right to freedom shall be restricted? So this is like sovereignty and integrity of India, then friendly relations with the foreign states, public order, decency and morality, contempt of court, interest of scheduled castes and tribes, general public interest. So it is said to have causing the issue to the integrity of India, then the state can cut off that. Then suppose a state has a friendly relationships with the foreign states, and the I have been raising certain issues against them, then that has to be cut. Then on the concept of morality and decency also, then contempt of court. I violating the court order and saying that it restricts my freedom, so that shall also be a reasonable restriction. Then Article 20 is no person shall be convicted for an offense except for violation of law. So this Article 20, 21 are also very crucially important. So I, as a citizen of India, the citizen of India shall not be convicted for an offense. So except for the violation of law, and also the citizen shall not be punished twice for the same law, for the same violation that they have done. So, and also they shall not be forced to be forced to be witnessed. Like, suppose a convicted person cannot be the witness in their own case. I hope you understand. I don't know how do you turn it out to Telugu, but Okay, that I'll try for the another day. Uh, if a person is said to have violated something case, so that person cannot be forced to be uh, witness ఆయన కేసులో ఆయననే ఒక సాక్షి లాగా చెప్పకూడదు. Okay, they cannot be compelled to say so. So I hope you understood. Then Article 21 deals with protection for life and personal liberty. Again, a crucial, important article. Then deprived of his life and liberty except according to the procedure established by law. So I cannot be deprived of my life, right to life and liberty, except according to procedures certainly established by law. If it's for the protection of the national integrity or the national emergency, all those during such times. Now, next one is Article 20. Procedure established by law means avoiding punishment as per the procedure only. You cannot take grudge over me saying that I have violated such certain things. Whatever the citizen is said to have violated certain things, the court can punish only according to the rules and regulations. So now Article 21A, another the blissful act, it is called right to education. This has been added through 86th Amendment Act 2002. This is also very important MCQ question. Now what happens in this Article 21A is state is compelled, and it is compulsory for the state to provide free and compulsory education for all the children to between the age of 6 to 14 years. So the state, if you look through the government policies, the state should and must provide free education. So it is not doing some favor by establishing schools, by providing education, by providing the certain necessary amenities. So it is the fundamental right of any children to get this education from 6 to 14 years of age to be provided by the state. Then Article 22 deals with another important thing, protection against arbitrary arrest. So, and also detention cases. So, this Sedition Act and all comes under this. Then, no person who is arrested shall be detained in custody without being informed. Suppose a person is arrested and they shall not be, unless they shall not be detained in custody without them being informed or without them being presented before the magistrate, and also the person convicted person have right to consult their own legal lawyer. Practitioner means their own lawyer. So the convicted person has right to consult the lawyer of their choice. You cannot force that convicted person to only go with certain lawyer that the state is gonna give. So they have right to do. And the next one is they cannot be detained beyond 24 hours without the authority of district magistrate. So they have to be presented somehow within the 24 hours. So exceptions are like holidays and all, but this all things are not feasible or possible if a person is detained under Preventive Detention Act. So the again the Sedition Act and the cruel historical act comes into picture here. So if these are all possible for a normal detention, so but under Preventive Detention Act, the detained person cannot uh, be can could be arrested without being informed. Then they have no right to be defended by a legal practitioner, and it is not compulsory for them to be presented before the authority of magistrate. Yes, and parliament and state legislatures have power to pass preventive detention acts to attain or detain or imprison any person without trial. Yes. So this is very crucial or law, and these are could be seen in some of the acts like internal maintenance of internal MISA Act, which is very popular. Then MISA Act, Maintenance of Internal Security Act, then Conservation of Foreign Exchange, Prevent of Smuggling Act, National Security Act 1995. So if you remember these acts and years also well and good, they are very important for uh, competitive exams. Now next comes right against exploitation. Now what is this right against exploitation 23 and 24? Supplementary, these are called as a supplementary act to the right to freedom. Now what is this supplementary act to right to freedom? So we'll go to right to freedom 19 to 22. So this is basically like freedom of expression, union, then possibility, then protection of life, liberty, then offense, then preventive detention, so then right to education. So this act is against the exploitation and supplementary. Then Article 23 prohibits human in traffic. Uh, then article is not absolute, then state can impose. So this is like the right against exploitation. So this is supplementary to right to freedom. We have why it is supplementary, you will understand here. Now Article 23 does what? It prohibits traffic in human beings and all sorts of inhuman acts like sales or purchase. Then article is not absolute, of course, because state can impose compulsory service for public purposes. So this is a limitation or restriction. Then if there's a question supposedly says Article 23, which is prohibition of human beings trafficking and all sorts of human case, this is not this is absolute this is an absolute article. Then the option only one is right. Option two is wrong because it is not absolute. State can impose possible compulsory service restrictions. Then Article 24 is children below 14 years of age shall not be employed to any work in factory or mine or engage in any hazardous employment. Yes, this is as per Child Labor Act. Yes, this is also a very important thing. So this restricts people below. And you can see in Article 21A, the government has provided free education to all, compulsory and free education to all for from age of 6 to 14. So people belonging to age to 6 to 14, they shall be given free education. They shall be rather in school rather than working in hazardous institutions or hazardous factories. Now, next one is right to religion. Right to religion is also very important or typical, little bit tricky question, little bit tricky article. So, 25 to 28 and secular was added through 42nd Constitutional Amendment Act 1976. You all know this. Then Article 25, what does this say? Like as a person, they can profess, they are entitled to profess and practice any religion of their interest. So this they cannot be compelled to practice only one religion because India is a secular nation and it does not have any state religion. Okay, so it gives equal access or equal distance or equality to all citizens, right? So the government also does not recognize any official religion. Government then Article 26 confers upon religious groups the freedom to manage their religious affairs. So the religious groups, the people who profess the religion, they have under Article 26, they have this freedom to manage their own religion and conduct these meetings and all. Except these meetings shall not be against national integrity. Now, Article 27 says states shall not impose or collect taxes from individual. Yes. Now, what happens here is the state shall not collect any taxes from a citizen in religious purposes, like you are you are following or you're professing such certain A religion or B religion. I cannot collect a tax saying that you are practicing a B religion, so that now pay me a tax. So that is not possible because it's not as a fundamental right. And Article 28 bans religious instructions in educational institutions. What educational institutions does it ban? Where the state will provide aid, like state will give this beneficiary or subsidies, where state is partially providing benefits or state has totally controlled it. There, such institutions, nobody has right to profess or practice or push them to practice only certain religions because state has been involved. So because we are a secular nation, right? I hope you are all following the lecture. So then next comes the cultural and educational rights. So the 29 to 30. So this cultural and educational rights, Article 29. Citizen of India shall have right to develop their own language, culture and script. Now I cannot be restricted for following certain language. I cannot be restricted for protecting that my script or the language I speak. Then Article 30 says all the minorities have right to establish and maintain excuse me, educational institutions of their choice to develop the script, language, and religion. No minority shall be restricted or no minority religion shall be restricted from maintaining their institutions or from protecting their script, from practicing their language, from practicing or preserving their dialect. So these all restrictions shall not be made. And state, while providing grant in aid to educational institutions, shall not discriminate an educational institution on ground that it is under the management of minority, whether a religious minority or the language minority or a linguistic minority. So this is also very this article 29 and 30, the questions you're going to get is, do we have a religious uh, the MCQ gonna be like, state providing shall not discriminate only on the basis of linguistic minorities, not on religious minorities. So the option is wrong because both religious and linguistic minorities shall not be discriminated. Now, next comes right to constitutional remedies. Again, they are called as heart of constitution by Dr. B.R. Ambedkar. Why? Why means you'll understand now. So, Article 32. Now, what does this Article 32 does is it does a very important thing. It's like the Supreme Court. It gives power to the Supreme Court to issue certain writ. WRIT. So, issue certain writ uh, for protecting the fundamental rights once they are said to have been violated. So I hope you understood what I'm trying to say. So now what are this? Now what does this Article 32 say is, it empowers the Supreme Court to issue certain writs, which in order which set when issue certain writs, can it issue writs is to protect the fundamental rights if they are seen to have been violated or threatened. And now, what are these certain writs? These writs are habeas corpus, mandamus, certiorari, prohibition, and quo warranto. So, again, an MCQ, you might get it as a match the following for the competitive exams. Also, a long answer question, explain various Article 32 with respect to the various writs that the Supreme Court and High Courts are empowered. So habeas corpus, mandamus, certiorari, prohibition, quo warranto. So these five writs you have to remember and their meaning and who they are applicable on and why they are applicable. You have to remember. This is there's no way going back. There's no alternative to it. Now, what is habeas corpus? Habeas corpus means to have body of. Now, what? What body? To have body of those person who have been detained. So issued, this is issued to an authority to present the detained person, matlab to have a body of them to be present. Then mandamus means command. Now who is commanding who? The courts are commanding public official for doing their duty or for not doing their duty. So commanding. Now, right. So that is commanding. Now, this commanding is only limited to the government officials. Now, the command, the mandamus writ shall not be applied to private authorities uh, or any associations or any the government officials for those who have discretionary powers. Okay, this now this is a tricky one here. You have to remember. So the mandamus means command. This is issued to a public authority, but not that public authority who has that discretionary powers, like inbuilt extra powers. So that cannot be issued against them, and also this shall not be issued against private body or private associations. Then certiorari means it is issued by superior court to an inferior court, means higher court to a lesser court, because this writ will prevent the lesser court in over in abusing their power or abusing their authority, which violates the fundamental rights of a citizen. And also, this certiorari also cannot be issued against a private authority or a private person or a private organizations or any societies. And also, this certiorari is interestingly is not applicable to environmental cases. So this also an important MCQ. Then prohibition. Now, prohibition is also issued by the Supreme Court or High Court to the lower courts. Same thing as certiorari. Now, what is the difference between certiorari or prohibition? Certiorari is issued once the violation has been done, but the prohibition is issued before the violation could be done or before the violation was said to have been happening. Okay, before the court judgments have been given. So the certiorari is given once the inferior court have said to have given its judgment, which is abuse of power, which is said to have been abuse of power. Now, prohibition is issued before the proceedings have been happening, a final judgment has been come. So this is a difference. Again, you have to remember the difference also. Then co-warrantum is by what authority and warrant do you have to in proceeding in certain cases. So these are all five writs that you have to remember. First one is mandamus, sorry, habeas corpus, mandamus, certiorari, prohibition, and quo warranto. Very important. Now, next comes another crucial thing, the controversies, or why did we have limitations to the fundamental rights which are said to have protected the, which are said to have to protect the citizens' freedom, liberties, expression of thought, etc. But these limitations have come across through the challenges to the fundamental rights, uh, to certain court judgments and amendments that have been made and repealed, and court judgments withdrawn, repealed, and new judgments have come in place. Now, these things could be seen in Shankari Prasad case, Golaknath case, and the historical Keshavananda Bharati case. Now, Shankar Prasad case, what happens is smooth sailing to amend the constitution until 1967. So, in 1951, the parliament, the court has said that parliament has right to amend any part of constitution. Fine. So, the constitution was amended left, right, up, down until 1967 because Golaknath case said that parliament had power to take away or abridge, no power to take away or abridge any fundamental rights guaranteed by the constitution by amending the constitution itself. Okay, so this is what the Golaknath case has said. Then the court held that the word law of 13 shall apply to both ordinary law and constitutional law. So now what the argument was done was the article 13, which represents the word law. So they said that it does not have the, that did not mention that the law has to be an ordinary law or a constitutional law. So let us do a constitutional law by amending the fundamental rights. Now, this clear cut said that Golaknath case, the law 13, the word law of Article 13 applies to both ordinary and the constitutional law, constitutional amendments. Yes, so it reversed the Shankari or Shankar Prasad case. Then next comes another historical cases. Keshavananda Bharati case, 1973. Now, what happens in this is Parliament could amend only certain parts where the fundamental rights or amendments to such things should not be said to have violated the fundamental rights. Okay, so the same thing. I think this was during the certain amendments to the 42nd or 44th. That time, the PSPs are said to be given upper hand rather than the fundamental rights. So here it established that the Parliament shall not amend any part where it's said to have violated the fundamental rights or the basic structure itself. Okay, so this is what the Keshavananda Bharati case is. So there are many limitations to the fundamental rights. Now we are evaluating the pros and cons of fundamental rights. So now what happens is there are many limitations. You saw already in the slides that if there's an article, there's a limited or restriction article to it. So you well and said that is what confused people as a citizen of India, and also language is very typical. Then that those are the limitations. Then lack of social and economic rights. So if you go through the fundamental rights, there is no certain act or there is no certain article which mentions the economic or social rights like right to work, right to social security, or right to leisure, anything as such. So this lacks the social and economic inclusion. So this kind of truly political in nature, we can say that. Then it is controversy with regards to the amendments. Yes, the amendments, once until the Kesavananda Bharati case, 1973, have established that the parliament cannot amend the basic structure itself. The articles saw, or the constitution saw various amendments which said to have overthrown or violated the basic fundamental rights of the citizens. Then it is highly technical. This is the constitution is lawyer's paradise, of course. So it being a technical, it cannot be understood by a common man. Let's suppose you are a graduate in political science, and you have to remember this, what are the fundamental rights and the limited restrictions your entire life, but it's a huge task for you to remember. So you being a graduate who studies what are fundamental rights all along 3 years and all along their life, sometimes it becomes difficult even for you to understand. Then how do anybody can expect a common citizen to understand those uh, the highly technical fundamental rights and their limitations around it? So which is not that quite commonly possible, right? And also, if you try explaining something to the illiterate people, then the rural areas people or remote areas people, like these are your rights, do you think that it would be easy for them to understand? Which is not quite possible. Like, but also it falls on the duty of the government to help them educate people about what are their rights and etc. But that is like secondary inclusion. Initially the citizen has to understand that they have certain rights, right? The concept comes from there itself. Then there's a conflict between fundamental rights and the directive principles of state policy. So there's a positive discrimination, there's a non-discrimination in DPSPs, and they follow a liberal Marxist and Gandhian approach. Here, the approach is the straightforward. So, and also in terms of violation of any article, should I give suppose in making a policy, should I give preference to DPSP first or fundamental rights first? So there's a little tricky thing in making such policies. Now there's a vast gap between theory and practice. So this is what happens. So in theory, in previous things, this is all theory we have read. Like this is theory, like empower Supreme Court to issue etc. to certain uh, acts, issue rates against the violation. But the practice, what happens is this is not applicable to environmental cases. Like how do they come up with such things? So somebody might have went to the court for saying that this inferior court has been misusing their power, etc., and all those things. So that is why this is in while coming to practice, the little restrictions have been coming. So I think the theory has been made as such. The restrictions or limitations have come in place only after the practice of those fundamental rights or the court judgments or rereading or the constant amendments to them have evolved the gap or increased the gap between actual theory and their actual practice in day-to-day life. So this is what the fundamental rights that we have read today. So if any, the possible question would be like, they'll ask you to write, uh, yeah, so what they'll ask you to write is, so the possible questions would be this one, like explain the evolution of fundamental rights, or the certain features of like how does my right to life or freedom of expression is addressed or is protected through articles. What are the certain articles you have to explain? Then the next question is the characteristics of fundamental rights. Let's suppose the question could be like right to equality, like equality, equal protection of law. Then explain how does the constitution protects it. Then also the right against exploitation thing. Then right to life all those things, how it is addressed that the things are protected. So in that case only they'll ask you the questions. And also they'll say, in case of discrepancy between fundamental rights and fundamental duties, what has to be addressed. So after DPS, sorry, fundamental rights and DPSPs, what has to be taken into consideration. So that you can read, that you will understand after once we finish DPSP's lecture. So that, like that also they can ask you a question. Then next comes the question, like mostly they don't ask you write about article 19, they won't ask you write about article 20 like that. They'll ask you like this is more descriptive. They'll test your fundamental knowledge. So now what they are going to ask you is like the challenges to the fundamental rights. Not just, they won't ask right challenges to the fundamental rights. So the possible question would be, suppose in case of violation, or suppose in case of discrepancies, can parliament amend certain fundamental rights, or then can parliament amend such things. Then in that question you can explain the cases, then give a conclusion that parliament actions are restricted by Keshwananda Bharati case, etc. Like that, you have to analyze it, and write it in your thing. And of course, every question has to have a criticism or possible critical appraisal. So you have to mention, you just not have to praise the fundamental rights always, because you can see by yourself that there's a huge gap. There are certain limitations to it. So you can also end the answer with the limitations and summarize that although there are restrictions or limitations, but these are fundamentally necessary for me to be being as a citizen of India, which helps me maintain my freedom of expression, life, thought, etc. All those things like that you can understand. So I hope everybody is clear today. So we'll end the lecture in 20 seconds. Then I hope everybody is clear today, fundamental rights, and expecting you to understand the fundamental rights the easier way. So, so I'll be signing off now. And so these are the possibilities. You can go through the slides on they are displayed on YouTube live, I think. So yeah, see you in next class.